Hello everyone, and welcome to Registrar Corp's webinar entitled US FDA Foreign Supplier Verification Program FSVP Requirements. My name is Jonathan Rhodes, a marketing specialist at Registrar Corp and today's moderator. This presentation will conclude with a live questions and answers session. If we run out of time, we are also happy to respond to your questions by email. You may submit a written question anytime during the webinar by using the Ask a Question feature in the top center of your webinar screen. A recorded copy of this presentation will be sent to all registrants. I'd like to introduce our speaker today. Fabiola Negron holds a Bachelor of Science in Industrial Microbiology and pursued graduate coursework in Food Science and Technology at the University of Puerto Rico. She has successfully completed food safety training in good manufacturing practice and sanitation standard operation procedure, preventive controls for human foods, seafood and juice HACCP, foreign supplier verification programs, and others. Ms. Negron acts as Registrar Corp's Manager of Food Safety. She and her team assist food facilities to comply with US FDA food safety regulations by reviewing HACCP and HARPC food safety plans, developing foreign supplier verification programs, and more. They also offer services to act as the qualified individual for FSVP importers. I'd like to go ahead and begin. Fabiola?
Thank you so much, Jonathan. Hello, everyone. As mentioned, we will be talking about FSVP requirements today. In general, we're going to start with the FSMA, then we're going to jump into the FSVP rule, FDA's enforcement of FSVP, including inspections, top violations, and consequences of non-compliance. Then we'll just, in general, talk about compliance dates and have our question session. So FSMA was signed into law in 2011 by former President Obama. The finalizations of the rules began in September of 2015 with the preventive controls for human and animal foods. Then came the Foreign Supplier Verification Program in November with the third-party verification and produce safety rule. After that came the Sanitary Transportation Act for sanitary transportation of foods. Then came the Intentional Adulteration Rule or Food Defense. And finally came the Voluntary Qualified Importer Program. This is a voluntary program in which importers can fast-track their foods through the port for a fee. So the applicability of the FSVP rule, FSVP applies to human foods, dietary supplements, produce, low-ask canned foods, animal food, and even samples for trade shows. So if you're bringing samples into the United States, for a trade show, if they will be served to the public at that trade show, you would need an FSVP. Exempt from the FSVP rule are juice and seafood, as they're subject to HACCP and already have importer requirements in place for regulation. Alcoholic beverages are also exempt. USDA products, which are subject to USDA. Food that is solely for research or evaluation. So if you're importing samples to test in your laboratory or your R&D team is going to make some testing, that would be exempt. If it's food for personal consumption, if it's food that is transshipped through the United States, it will not be consumed here in the United States. It is exempt. Food for processing and exporting, and then food that is processed in the United States, exported and returned, also exempt from FSVP. In terms of requirements, the importers must perform a risk-based foreign supplier verification program in which they conduct verification activities to verify that the food is produced in compliance with the applicable FDA regulations, that the food is not adulterated, and that the food is not misbranded concerning food allergens. This applies only to human food. Allergen requirements do not apply to animal feed. And it aligns with the requirements for the supply chain program in the Preventive Controls Regulation. So food manufacturers subject to preventive controls are required to also have a supply chain program when their suppliers are controlling hazards. So it is basically the same requirement that importers have to check on their suppliers' compliance. So they are exactly the same requirements. If you are a food manufacturer in the United States and you are importing your raw materials and your suppliers are controlling hazards in those raw materials, you have to have your supply chain program, which is the equivalent of FSVP. In determining who is a U.S. importer, FDA defines the U.S. importer as the U.S. owner or consignee of an article of food at the time of entry. If there is no U.S. owner or consignee of an article of food at the time of U.S. entry, the importer is the U.S. agent or representative of the foreign owner or consignee at the time of entry, as confirmed in a signed statement of consent to serve as the importer under this subpart. So the U.S. owner or consignee is the person in the United States who at the time of U.S. entry either owns the food, has purchased the food, or has agreed in writing to purchase the food. So if there is a previous agreement that that food is destined to a specific consignee in the United States, there is an agreement, there is a purchase order, you are the owner of that food, and you are responsible for FSVP. So if you meet these definitions, you are the FSVP importer. So in determining who is the U.S. importer for FSVP, there is sometimes some confusion. For example, the FSVP U.S. importer is different from the importer of record for Custom Border Patrol requirements. So if you are the importer of record and you are, doing all those tasks to get that food into the country legally, you are in charge of paying fees and making sure that that product has paid all their duties. You may be, but you're not automatically the U.S. importer for FSVP. If you are the owner of the food, then you would also be the FSVP importer. However, if you're only doing transaction, you do not own the food, you are not the FSVP importer. The FSVP U.S. importer must be physically present in the United States. That is also a difference from the importer of record for CBP, which is not required to be in the United States. It can be somebody who lives in another country. The FSVP importer cannot be just an empty office space, a mailbox, or an answering machine. FDA will visit the FSVP importer for inspection, and they expect the FSVP importer to be in the United States. When multiple entities own the same food, there are different cases. There may be the case where a U.S. distributor is the owner of the food and then resells that product to another customer. So both of those people, the U.S. distributor and their customer, could be the FSVP importer because they both meet the definition of U.S. owner of the food. However, they can establish which of both are going to perform the activities under FSVP. Now, there is another case where an entry can have multiple unaffiliated owners. So you're sending that product, they're sending that product from another country, and it has different owners across the United States. In that case, everyone must have an FSVP, unless there's one of the entities that are agreeing to act as FSVP for all the other persons, and that must be also in a signed statement of consent. So if there is one entry of food that belongs to multiple owners, then all of them must have FSVP, and FDA will, request those FSVP during inspection. So the FSVP regulation requires different components and responsibilities. You must have a hazard analysis. You must have a supplier evaluation and approval process. You must have determined supplier verification activities. You must have conduct corrective actions when necessary, when there's an issue with the food. You must monitor your suppliers for compliance to ensure that they are maintaining that level of public health protection. You must have a qualified individual to conduct all FSVP related activities, and you must identify yourself as the importer at entry. Of course, all of these activities require you to keep records or document your activities and keep record of conducting those activities. And we will go through each separately. So we mentioned that you have to have a hazard analysis, and this applies for each type of food that you import, and you must conduct the written hazard analysis identifying the potential, reasonably foreseeable biological, chemical, and physical food safety hazards. So this can be bacteria, it could be pesticide residues, mycotoxins, heavy metals, undeclared allergens, which is the number one cause for recalls and is also a very important food safety hazard. Also, if your food contains food intolerant substances like yellow number 5 or sulfites, which are also dangerous for sensitive individuals. Foreign matter, anything that can cause injury or a choking hazard to your consumers, must be identified as well. And you have to account or consider the probability that the hazard will occur in the absence of a control, and assess also the severity of the illness or injury that it would cause to humans if the hazards were to occur. And you have to identify the controls that are applied by your supplier. So we need to have a written hazard analysis for each type of food, and each type of food means categories. You can have food grouped into a category. You can have baked goods, you can have candies, you can have chocolates, you can have cookies. There are different hazards associated to those different categories of food. So in looking at your supplier's process, you would evaluate, if the processes are similar, the hazards are similar, you can group into one FSVP. And all these FSVPs must be per supplier as well. So if you have 2 suppliers of cookies, you would have 2 different FSVPs. I mentioned you need to have a qualified individual to conduct these activities. And a qualified individual is a person who has the education, training, or experience, or a combination thereof, necessary to perform an activity required under this subpart, and can read and understand the language of any records that the person must review in performing this activity. A qualified individual may be, but is not required to be, an employee of the importer. They also make the distinction that a government employee, including a foreign government employee, may be a qualified individual. And that last part applies mostly to on-site audits. So if your foreign supplier has an audit or an inspection by another food safety authority, whoever is conducting that inspection would be considered a qualified individual. But in terms of the FSVP, all FSVP related activities must be conducted by somebody who has the education, training, or experience in either food science or food safety, food processing. They must understand the hazards associated to a food. They must have the capabilities of evaluating your supplier's compliance, understanding the regulations, understanding the requirements in order to make adequate determinations in your FSVP. We also said you need to conduct a supplier evaluation and approval. So you have to evaluate your foreign supplier's performance and risk posed by the food. So you have to consider the results of your hazard analysis, what were the hazards that you identified and the controls that are necessary, which entities are controlling the hazards. Sometimes there may be multiple entities involved in the processing of a food, and one of them may control certain hazards and the other may control other hazards. So you have to consider who is controlling the hazards in my food, and you have to verify that each entity is performing the adequate practices to control those hazards. You must evaluate the procedures, processes, and practices that they have in place at their facility for food safety. You must ensure that they are compliant with FDA food safety regulations. So you have to understand your food, the FDA applicable regulations, and then ensure that your foreign supplier is following those regulations. They could be preventive controls, bird safety, are they dietary supplements, are they canned foods? So you have to understand those requirements. You also must consider FDA compliance history. Have they had a recent inspection? Have they had warning letters before? Have they been subject to detentions or recalls or import alerts? So you have to understand your foreign supplier's compliance history to ensure that you have evaluated that and that you put proper verification activities in place. And you don't want to approve somebody who has a terrible history of compliance, because that would also mean issues for yourself and your consumers. Then the food safety history. It's possible that you've already been requesting, certificates of analysis, testing of the foods for hazards, that you have been requesting audit reports. It could be BRC or SQF. You have GFSI. So some importers have already been requesting these evidences of having a food safety system in place and having certain standards for food safety. So if you have a history, you can evaluate those and say, well, so far I've had no issues with them. That's part of your supporting documents for your FSVP approval. And FDA requires that you approve a supplier for which you have determined compliance with FDA regulations, and only the type of food for which the associated hazards are being adequately controlled. So you must ensure that evaluation, that you are only approving suppliers that have demonstrated compliance with FDA, that have a good food safety history, because you are now the gatekeepers for the United States food safety. So you have to make sure that you are approving your suppliers based on those determinations. And it is possible for a supplier to be compliant with some FDA regulations and not others. For example, you may have a supplier that does canned foods. Let's say they do canned beans, and they also process dry beans. So it's possible they're compliant with the dry beans. Yes, they are compliant with FDA regulations. They follow GMPs. They have the controls in place for the dry beans. However, for the canned foods, they're not complying with low acid canned food regulation. And it's possible that you can approve the dry beans, but then you decide not to approve the canned beans because they're not in compliance with FDA. So you have to, that's why you have to evaluate different categories of food separately, so you may properly address the applicable regulations. So after you've done that evaluation, you have conducted your hazard analysis, you have the full picture of what your supplier is doing or is not doing, then you have to determine verification activities. And they have to be appropriate to ensure that your food is safe. So it depends on the results of those evaluations that then you determine proper verification activities. If there are different types of verification, and it could be annual on-site audit, it could be sampling and testing, or review of your foreign supplier's food safety records. And you have to have written procedures on how you're going to conduct those verification activities, how you determine verification activities. And you have to have procedures to make sure that you use approved suppliers and that the appropriate verification activities will be conducted. And you have to review and assess the results of verification activities. If those verification activities are evidence that your foreign supplier is not in compliance, they had positive results for pathogenic bacteria, or they had high levels of mycotoxins or pesticide residues, then you must take appropriate corrective action. Corrective actions are necessary to make sure that your foreign supplier fixes the issue and that it doesn't recur. You have to maintain awareness of your supplier's compliance. It is very important, and we've had many cases where FDA will only, they're not required to contact the FSVP importer specifically when something happens with your foreign supplier. They will contact the importer of the food. Sometimes even the foreign supplier is not aware that they've been detained or that their shipment, they're on import alert. So this communication might not get to you. So it is important to maintain that level of awareness of your supplier's FDA compliance, so you may take corrective action as necessary. Sometimes knowing their compliance with FDA can also help prevent issues that, even though you haven't had issues with that supplier before, it doesn't mean it won't happen to you at some point. So you must understand what your foreign supplier is doing. We mentioned that corrective actions must be taken when you are made aware of an issue. So if your supplier is not producing food in compliance with the applicable regulations, if you determine that the food is adulterated or that the products are misbranded regarding major allergens, you must take appropriate corrective action. And they include notifying your foreign supplier of the problem and requesting them to provide their corrective actions. So you can review what actions the supplier is taking in order to fix the issue so it doesn't happen again. You can assist the foreign supplier in correcting the problem. So if you understand the regulation, if your qualified individual has the experience, they can also advise your foreign supplier, and maybe you understand the FDA regulations better, and we can explain to the foreign supplier how to fix the issue, what they need to do, how they can demonstrate it, and you can assist in that process. Then conducting by yourself a recall of an adulterated food. If the food is adulterated and has been distributed, you have to conduct a recall to make sure you're not harming your consumers. Then that also may include revising your FSVP. Like, the verification activities that you were conducting before are no longer going to work. You need to conduct, more in-depth verification activities, or you have to conduct them more frequently to make sure it doesn't happen again. So that could also include revising your FSVP, including a new hazard that wasn't there before. So that's something that you also have to do when conducting for corrective actions. It may include also discontinuing use of the foreign supplier. So if your foreign supplier is unable to fix the issue, or they are not willing to fix the issue, then you may need to discontinue use of that foreign supplier, because you can only use suppliers in compliance with FDA. You must also identify yourself at the port of entry as the FSVP importer. So the regulation says that for each line entry of food product offered for importation into the United States, the FSVP importer must ensure that this information is identified, and it is the importer's name, their email address, and their UFI, recognized as acceptable by FDA. That so far is the DUNS number. And you must keep records of all FSVP related activities. So your hazard analysis, the type of food, you could have their labels, you could have, you need to identify you include your evaluation process for approval, your written procedures to ensure you only use approved suppliers, your corrective actions that you've taken. All those documents you need to sign and date. And at the time that you develop or create those documents or conduct the activity, you have to keep those records for FDA when they inspect you. So you can keep as original records, true copies, or electronic records. You must sign and date the records concerning your FSVP. All records must be legible and stored to prevent deterioration or loss. They need to be made promptly available to FDA upon request. So when FDA contacts you, you must be able to promptly deliver those documents to them or provide those documents to them. They will request to translate to English if those documents are in another language. And if you have your records stored off-site, they have to be able to be retrieved within 24 hours. And you need to keep records for at least the past 2 years. There are certain modified requirements in terms of FSVP. The dietary supplements regulation, for example, it is not under preventive control. So FSVP is part of FSMA. It's a new requirement. It aligns, like I mentioned, with the supply chain program of preventive controls. It is generally or mostly created to be related to the preventive controls rule. However, in the modified requirements, then it makes the exemption. For dietary supplements, you do not need to make sure your supplier is complying with preventive controls. You have to ensure they're complying with the CGMPs for dietary supplements, which is a different regulation. Also, covered produce, different regulation. You have to follow produce safety, not preventive controls. Also, if you're a very small importer or importing food from certain small suppliers, you have to comply with some sections of FSVP. So you have a shorter version of the requirements instead of standard requirements. So you would not have to have a hazard analysis or evaluation of the supplier for approval or conducting verification activities. Very small importers or importers that are importing from very small suppliers are required to request written assurances, and they just have to make sure that that written assurance states their suppliers are complying with the applicable FDA regulations every 2 years. So there are very limited requirements for those smaller businesses. Then there are also certain foods from foreign suppliers in a country with a food safety systems recognition agreement. And this includes Canada, New Zealand, and Australia. So these three countries, FDA has deemed them as having a comparable food safety system. Therefore, if they're complying with their food safety authorities, they will be deemed in compliance with FDA. And also very limited FSVP requirements. You just must ensure that they have a evidence that they are in compliance and under the scope of the FSVP or FSMA regulations under that agreement, and that they're complying with their food safety authority. So here we have a little summary, so you can also read on your own time. So for the very small importers are those importers that have in sales and market value of the food that they import, manufacture, process, pack, or hold is less than 1 million for human food or less than 2.5 million for animal food, and that includes foreign and domestic subsidiaries and affiliates. So if you have a parent company, you must also include their sales and market value of the food in your calculations. And also for very small importers, as I mentioned, you would have to request a written assurance from your foreign supplier that they're in compliance with FDA, and you have to identify yourself at entry, just like with every other requirement. So then if you're importing from certain small foreign suppliers, which would also be called qualified facilities for food facilities under preventive controls, or that farms that have a qualified exemption, so there are small farms or shell-egg producers with less than 3,000 laying hens, these are considered certain small foreign suppliers. These do not apply to dietary supplements or if food subject to other regulations. It only applies to those subjects to preventive controls or the produce safety rule. And the requirements are also written assurance every 2 years, and they are exempt from having a food safety plan or supply chain program. So that's also why the FSVP is a shorter version, because the foreign supplier would not require to have a food safety plan. So you would not have to review their hazard analysis. And then for those who have a food safety systems recognition agreement, the requirements are that they are under the oversight and in good compliance standing with their food safety authority, that the food is within the scope of the agreement, and just monitor that compliance is maintained. FSVP in enforcement so far, FDA is actively inspecting. They have been actively doing so for a couple of years now. And, they're moving more towards the enforcement rather than education. They still provide some education and may answer some questions that you may have. They always do that. However, they are now actively, you should already be compliant. So they are being more strict with the regulation. So that started a while ago. So the FSVP inspection, what to expect. FSVP inspections are unannounced. FDA, well, now due to COVID, they're doing remote inspections, but once everything hopefully gets back to normal, they can do in-person inspections again. But they are not required to announce domestic inspections, so they can just knock on your door. The FDA inspector will present their request for FSVP records to the most responsible individual of the firm, so that could be the owner of the firm. And FDA may request the FSVP related documents to, pertaining to one or multiple suppliers and products. So they could just ask for one, or they could ask for 3, 4, 5, whatever they deem is necessary. And they will request the FSVP, your written procedures, your verification records, your corrective actions, if any have been taken, supporting documents for the FSVP. So they may request your foreign suppliers hazard analysis, the controls they have in place, their audit reports. They're going to request all of that information. FDA can also review your product labels, so make sure that you have those available as well. They can review purchase orders just to make sure they have, to confirm who the owner of the food is at entry. They could request tax information if it's a very small importer, just to make sure that you meet the requirements for very small importer. They will request your annual sales and market value of the food to make sure that you meet those requirements. Then they will review all that information and they will close the inspection, and any non-compliance will be recorded in a Form 43A, FSVP observations. And there they will list your non-compliance, and they will allow you 15 days to respond. Once you respond, you have to say what corrective actions you've taken to address those observations. If you did not have any compliance issues, no 483 will be issued to you. Then also, more serious regulatory action may be taken if the observations are very high risk, like if it requires you to conduct a recall, they will request you to do a recall, or if you do not respond with appropriate corrective actions, they may issue a warning letter. If it's a recurring issue or it's something that is more serious, they could place you on import alert. But being placed on import alert would take several non-compliances, not from the usually it would not be from the first inspection you would be placed on import alert. So here we have an example of an email that FDA sends to request FSVP information from the importer. So that's why you're required to provide your email address, as FDA can communicate directly with the importer. So it would say your email address was identified as the email address for your firm's FSVP point of contact. Your firm was identified as the FSVP importer for the following entries of food. And they could list several entries and several categories of food and suppliers. So they will provide the entry number so you can corroborate, or confirm with your records if you are indeed the owner of the food. The approximate date of entry, they will describe the food, which is the food category that was imported, and the name of the foreign manufacturer. So it will give you the definition of who the U.S. owner or consignee is to make sure that you remember, and if you can confirm whether you meet that definition for that particular entry or not. And you can let FDA know if that entry was not yours. So we've had that case where clients can be listed as FSVP importer for a food that they did not purchase, that they do not import. Sometimes foreign suppliers or other importers could, make the mistake of assuming that food is yours, or the wrong information was provided to the customs broker at entry. So those errors do happen, or miscommunications. So you have to be aware, just make sure that you have all your documents up to date so you can confirm whether or not you are indeed the U.S. owner of a food at entry. So there have been, FDA, as we mentioned, is actively inspecting and enforcing FSVP. And the number one violation during these inspections is the failure to develop an FSVP. So we see in this chart that in 2017, there were 108 483s issued with this observation. Specifically. And then in 2018, when it was already enforced for over a year, that number went up to 289. So 160%, a 68% increase in that specific violation. And so forth, as we see, this continues to be the number one inspection violation each year. And you must be prepared. You must develop that FSVP. So there are other common violations regarding FSVP. So some importers already write their FSVP, but they fail to follow it. This is a document that you must always keep up to date. If you determine that you will conduct verification activities quarterly or annually or every shipment, you must ensure that you follow the procedures that you established in your FSVP. Another observation is FSVP did not provide adequate assurances. So if your FSVP does not provide the assurance that the food that you're importing is safe, this is also an issue. You must ensure that you have a qualified individual developing and implementing your FSVP to make sure that the FSVP is adequate, that it provides those assurances that the food imported is safe, that you have proper verification activities in place in accordance to what FDA expects, and in accordance to FDA regulations. So failure to sign and date the FSVP, you must approve that FSVP. The importer must review it and ensure, they agree with it, they sign and date, that the qualified individual also signs and dates any records related to the FSVP. And then the other observation is failure to provide English translation of an FSVP record. So since this is the foreign supplier verification program, you're importing from different countries. They may speak Spanish, Chinese, Italian, French, and their documents and their facilities are in those languages. And FDA does require the qualified individual to be able to understand those documents, and you do not need to translate all of them once you receive them for your review. However, once FDA inspects and they are requesting specific documentation, the documentation that you provide to FDA must be in English. So consequences of non-compliance. We touched on a little bit of these in the previous slide. However, we'll go into more detail now. So if you do not meet FSVP requirements, if the food that you import is deemed, not safe, it could mean that starting with an inspection and a 483 after you are not providing adequate corrective actions, then FDA can follow up with warning letters. And that also depends on the risk of the non-compliance. So FDA can issue a warning letter at any time. And those warning letters are made public. So everyone in the world can see that your facility or that you as an importer got a warning letter. So it is very important to make sure that you're compliant, that if you do receive a 483, that you are quick to respond to FDA with adequate corrective actions. So that's why it is important to have a qualified individual in your operation. Recalls can be a consequence of non-compliance if the food has been distributed and it may harm the public. Detentions at the port. So if the food imported is not safe, FDA does actively do sampling and testing at the port. They do reviews of labels at the port. So if your food is not complying, if they deem that it is not safe or was not processed or manufactured in a sanitary environment, or that it has pathogenic bacteria, or it had high levels of pesticide residues, they do all different sorts of sampling and testing for different types of food depending on the risk. So if your food is deemed not safe, it could be detained and refused. You may be placed on import alert if you are not complying with FSVP, if you've had multiple instances, or the level of risk of your food is just too high. You and your foreign supplier can both be placed on import alert. And your foreign supplier can also receive any of these consequences of non-compliance. Now FDA has a window into your foreign supplier's compliance when they inspect you as an importer, because you're supposed to review your foreign supplier, have their food safety documents at your at your office, because you reviewed them, you ensured they were compliant. Now FDA goes to you instead of traveling all the way to your foreign supplier to see their compliance. So if they deem you not in compliance, and also your foreign supplier documents demonstrate that they're not complying with FDA, they can also take action against both you and your foreign supplier. So it is important that if your foreign supplier is not compliant and you still feel that they can get it together and you want to keep importing food, you must find a way to help them maintain that compliance so that both you and them can keep importing the food. Seizure and injunctions, civil and criminal charges, and collateral damage to company image. As I mentioned, all of these non-compliance, they're available for the public to see. So if your shipments were detained, if you're on import alert, if you conduct a recall, FDA warning letters, that is all public information, and it can damage your company image. FSVP compliance dates, they have all passed. Some FSVP compliance dates depend on the foreign supplier's FSMA compliance dates. So let's say you have the most recent one was one for animal food, and they were very small business, and it was a very particular food category. And it ended in, I believe, January 26th. So FSVP compliant for that particular, very specific type of product, the compliance for FSVP would be 6 months after that. So it is important you go to this link of FSMA final rules key dates, and if you have a foreign supply, you just look over your food category and find where your foreign supplier stands, and 6 months after that would have been your compliance date. But most of the FSVP compliance dates have passed. As I mentioned, there may be some very particular FSVP foreign supplier food categories that may still have some chance, but most of them have already passed. So it is important that you are compliant.
Thank you, Fabiola, for that great presentation. Before we move on to the questions and answers session, I'd like to just take a moment to discuss how Registrar can help with all of the things Fabiola discussed today. The first is our FSVP Development and Review Service. So Fabiola's team in her food safety department are all qualified individuals, and we can develop or review your FSVPs for FDA compliance. If you simply mention this webinar when inquiring about the FSVP service, you are eligible for a 10% discount on that assistance. Our second product that can help you comply with the FSVP regulation is our FDA Compliance Monitor. So Fabiola mentioned verification for your suppliers, and part of that verification involves documenting your supplier's FDA compliance history. As many importers may know, this is actually a very tedious and difficult task to do, because if I even have 5 suppliers, I have to comb FDA's databases for information about each of those suppliers constantly to make sure that they are still compliant with FDA regulations. The FDA Compliance Monitor takes that work away from you by continuously monitoring your suppliers for their registration number, any inspections they would have had, if they're on import alert, if they've been issued a warning letter, if they've had an import refusal, or if they're under recall. And all of this monitoring occurs 24/7 without your involvement, other than telling the system who your suppliers are. So you'll receive immediate email alerts when any of these compliance statuses change. And we also recently launched a new document management system to help you comply with documentation requirements under the Foreign Supplier Verification Program rule. So you're able to store your supplier's food safety plans, audit reports, any kind of documentation that you would like to collect to verify your supplier's compliance with FDA. The FDA Compliance Monitor is your comprehensive FSVP solution. It is a living, breathing solution, and by that I mean that Registrar Corp, we are constantly working with importers and food scientists to get feedback and better design the tool to comply with the FSVP regulation. So you can simply learn more at registrarcorp.com/monitor. So I would like to announce again that we will be sending a recorded copy of this webinar and a PDF copy of this presentation to all registrants. At this time, you may submit a written question by using the Ask a Question feature in the top center of your webinar screen. So we will now take our first question. And our first question is, we are an exporter to the US, so we are not the FSVP importer, correct?
Yes, that is correct. If you are the exporter, you are not subject to FSVP. Only the US owner of the food or consignee is subject to FSVP. And we mentioned that when there is no owner of the food in the United States, let's say you're just sending product to a warehouse, and when it reaches that warehouse, then other customers can buy the food. So at time of entry, there was no owner. That is the time when you will designate somebody else in the United States to act as your FSVP importer. So it can be your US agent or representative of the foreign owner. So that is the only time when you have to assign somebody different than whoever purchased your food already to be your FSVP importer.
Our next question. For a dietary supplement manufacturer, does the FSVP apply?
So if you are a manufacturer of dietary supplements in compliance with the dietary supplements regulation, you do not need to have an FSVP.
Okay, thank you. In the scenario where a Canadian manufacturer with no affiliate in the United States is sending product to several brokers/retailers in the United States, what are the FSVP options available?
So if you're a Canadian manufacturer, you do not need to comply with FSVP. You would have, your customers would have to comply with FSVP. So all of your customers need to have an FSVP for your food. But if you're a manufacturer in compliance with CFIA, the FSVP for your importers would be very very easy. Just demonstrate your compliance with CFIA by providing them your record of license, and that's just what they need to keep up to date to make sure that you're complying with CFIA.
The next question, how to check the product etiquette, and I believe by etiquette that means the label, before exporting to the USA from Europe.
So you would have to make sure that your label is complying with 21 CFR 101. And in regard to FSVP, the only requirement for compliance of labels is in regard to allergens. So the FSVP importer would have to make sure that they understand the ingredients in your food to make sure that you properly identified those labels in accordance to FDA requirements.
Thank you, Fabiola. I think this next question, this is a good opportunity to clarify a few things. If you are a foreign supplier, where do we find the U.S. importers that fulfill the FSVP?
So the U.S. importers are your customers. So if you have received a purchase order from a customer in the United States, they are the FSVP importer. And you would have to provide at entry with the customs broker their name, their email, and their DUNS number.
I'm seeing a few questions also. How do we define a small supplier?
So a small supplier is either a qualified facility, it can be a farm subject to a qualified exemption, or a farm that has less than 3,000 laying hens. So a qualified facility is a facility that manufactures, processes, packs, or holds foods for which their market value of the food and sales within the preceding 3 years average less than $1 million. So if your foreign supplier is subject to preventive controls and that average in the preceding 3 years is less than $1 million, they are considered a qualified facility. But for this, they also have to submit a qualified facility attestation to FDA to be considered as a qualified facility. So you have to ensure that they have submitted that to FDA. And once you do, then you can, rest assured they are a qualified facility and just request those written assurances from them for compliance.
Thank you, Fabiola. If we have a U.S. Department of Agriculture import permit for importing pet food, do we still need an FSVP?
Yes, you would still need an FSVP.
How specific is food category, frozen food or frozen berries or frozen blackberries versus raspberries and versus mango?
So in food category, FDA does not have a specific way for you to determine food categories. However, they do recommend that the foods grouped into an FSVP, they must be from the same foreign supplier. They must have the same food safety hazards associated. So let's say something like cookies and crackers. It's possible that you could group such foods within one FSVP. But let's say something like cookies versus a canned food, obviously those would be totally different regulations, different hazards associated to the food, different type of verification would be conducted. So that's why they say you must, for each type of food, have an FSVP for each foreign supplier. So you must be able to address within that FSVP the same hazards, the same controls, the same verification.
Is FSVP applicable for U.S. importers importing non-ready-to-eat products?
Yes. If there are hazards that all foreign suppliers, even if they're just doing raw materials, they are required to have, most of them, a food safety plan. So the importer in the United States, if that supplier is controlling hazards associated to the food, they must have an FSVP. Now, if they are a food manufacturer and they will further process that food and control all associated hazards, then they don't need an FSVP. They will address those hazards within their own food safety plan. However, if the foreign supplier there may be, let's say, wheat flour. Wheat flour can be used for baking, and it will be further processed, in that particular way that microbiological hazards can be controlled. But the wheat flour, there are certain hazards that need to be addressed by either the farm or whoever is storing that wheat, just to make sure they mycotoxins or pesticide residues are within compliance. So those controls for those chemical hazards would need to be applied by the foreign supplier. So in those cases, even though the food will be further processed, there are still hazards that need to be controlled previous to entry to the United States. So in those cases, the FSVP is required.
Thank you, Fabiola. Our next question, how do import alerts work?
Wow, that's a very general question. So import alert, that is like FDA's one of their last resorts when a foreign supplier or an importer are not in compliance. They've probably received multiple detentions, or they have been inspected and have failed inspections and have received warning letters. It's just a matter of, if it's a very high risk, you could be placed in import alert immediately. However, if there are other non-compliances, for example, you had some pesticide residues issues, you've been detained a couple times, you did not take appropriate actions, FDA can place you on import alert. It is not the first action they take. However, there was this outbreak of salmonella in pepper. So in that case, many facilities were placed on import alert for having salmonella in pepper. Other cases include high levels of pesticides. If you've had FDA non-compliance and you have not taken appropriate action, you can end up on import alert. And that means that for a specific type of food and, a foreign supplier, you would not be able to keep importing that category of food. There are some import alerts that are countrywide. For example, there could be an import alert for, I believe it was papaya from Mexico, if I'm not mistaken. So all papaya from Mexico could not enter the country unless they were placed on a green list. So that's a countrywide import alert where it doesn't matter if you're compliant. If you're papaya from Mexico, you would not be able to enter unless you demonstrate compliance and be placed on a green list. So there are different types of import alerts.
Thank you, Fabiola. My company is FDA registered. Is it the responsibility of the exporter to be registered with FDA, or does our company register them? And I assume that means as the importer.
Yes, it is your exporter's responsibility to register with FDA. So every facility that manufactures, processes, packs, or holds food that will be consumed in the United States needs to be registered with FDA.
Our next question, does Registrar Corp provide assistance for HACCP plan development or its verification to foreign manufacturers?
So we assist with HACCP plans. However, it's important to understand the difference between a HACCP plan and a food safety plan. A HACCP plan would be subject to seafood and juice, and a food safety plan is for other types of foods. In regard to FSVP, a HACCP plan for seafood and juice doesn't apply. So I'm assuming that was just a wording. Yeah, probably.
Our next question, our product is an additive sold to companies in the USA to process afterwards. Do we need to have an FSVP?
So I'm assuming you're an importer of this additive and you sell it to other companies. Yes, you would need an FSVP.
We do not have an FSVP and should have had one by now. Will the FDA go back and sanction us to the date when we were supposed to be in compliance?
I have not seen that happen, so I cannot be sure. They certainly could. I haven't seen it. They mostly expect you to have an FSVP already in place. I have not seen that particular observation yet in any 483.
For a dietary supplement manufacturer, we already have a vendor qualification program, but do we still need to comply and have FSVP and RM hazard analysis?
Yeah, I'm not sure I'm understanding that question. are you? I'm not understanding if they are the dietary supplement manufacturer or if they are an importer for a dietary supplement manufacturer.
So for this particular question, we encourage you. I've actually put our contact information up on the slide there. If you could email this question to info@registrarcorp.com, and we can respond to you at a later point.
Let me just assume that they are a dietary supplement manufacturer. If you're a dietary supplement manufacturer in the United States and you are in compliance with the CGMPs for dietary supplements, you would not need to have an FSVP because you're already complying with dietary supplement regulations.
Our next question, label approval, can it be grouped into product categories or must it be by the specific product?
So the FSVP does not require label approval per se. They require a review to make sure that it does include the major food allergens listed as applicable. So you could have a label approval in place if you want, and you can do it separately from the FSVP. But I recommend that you have the FSVP for a particular product and supplier have all the information together just to make sure that you are not, skipping any reviews or, you're able to keep that together.
And we are going to take our last question now. I see a lot of companies based outside of the U.S., which is great. And so this question, I think, actually more surrounds an exporter to the U.S. It says, we are a small producer and we want to export our product to the United States. How is the FDA facility inspection conducted? Will the inspector come to our country to provide the inspection?
So currently, FDA is not doing remote inspections. Not doing in-person inspections. They are doing inspections remotely. They might inspect your importer first if they were looking into your compliance. So next week, we're going to have our webinar for FDA inspections, and my colleague Rick Barham will have more information about what happens at an inspection, what you need to provide. But currently, they're not traveling to foreign countries to do inspections.
Correct. And so just to reiterate what Fabiola said, our webinar next week will be on the inspections, and you can find the registration link to that webinar at registrarcorp.com/events. Or alternatively, if you received an email invitation to this webinar, that information should also be on that email invitation. You can sign up for that there. We are now out of time, but I have placed Registrar Corp's contact information on the slide. We encourage you to send additional questions anytime by email to info@registrarcorp.com or contact one of our 20 offices worldwide for multilingual and regional support. This concludes our presentation. I'd like to thank everybody for joining us today.